Hello, and welcome to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. This show is presented to you by Gaslowitz Frankel, a law firm dedicated to resolving disputes involving your wealth, whether through your will, your trust, your business, or your investments. For news, pictures, and tips, go to our new website at gaslowitzfrankel.com or follow us on Twitter at Estate Dispute. Our show's hashtag is Wealth Matters. Your hosts are Robert Port and Millie Baumbusch, and today we're talking about the financial consequences of divorce.
And now it's time to introduce our guests. We are pleased to have with us today Steve Kirson, senior attorney with Kessler and Solomiany, Mike Bean, founder of Divorce Sense, and JoAnne Donner, founder and president of Donner Mediation and Coaching. And let's us first ask each of you to describe for our listeners a little bit more about each of your practices and an overview of what you do. Steve, let's start with you.
Thank you, Robert. I'm a divorce lawyer, and I've been practicing exclusively divorce and domestic relations law for 14 years. My firm is 12 lawyers, and we all practice in that area. I represent business owners, executives, and other individuals who are going through tough times in their life, and our plan is to get them through the process with as good an outcome as is available to them, and preserving the wealth is very central to that.
JoAnne, tell us a little bit more about your practice.
Thank you, Robert. I am a certified and registered mediator in the state of Georgia, and as a mediator, we work with two parties who are working to resolve issues. We do primarily divorce. As a mediation coach, I work with one individual who is facing a mediation, and I work with them to familiarize them with the process and get them to a point where they are comfortable and confident about walking into the mediation room. As a divorce coach, I work with individuals going through divorce, and I help them through all phases: pre-divorce, during divorce, post-divorce. A divorce coach is a sounding board, a thinking partner, a dedicated ally during a difficult time. So we work together through all the phases of divorce, helping them choose their professional team, how to work with that professional team, how to get their information organized, and how to help them achieve a successful outcome at the end.
And Mike, sounds like you'd be part of the team that JoAnne just mentioned. Tell our listeners what you generally offer for clients.
Well, first of all, thank you, Robert and Millie, for inviting me today. And you're right, we are what we describe as a central part of the team. We take a active role in the financial part of divorce. And I like to tell everybody the way my company was born was out of my divorce. My divorce was I'll call it a low to middle asset divorce 10 years ago, and it took us 14 months and tens of thousands of dollars. And I just sat back and said, this doesn't sound right. I don't understand why it took so long and why it was so expensive. So I sat down and I talked with my ex-wife at the time, and I asked her that question: why did this take so long? And she told me three things. One is, I didn't understand the financial settlement you proposed. And by the way, we did settle for 99% of what we talked about on day one when she had asked for the divorce. The second reason was, my attorney told me he could do better. And the third and last reason, which was astounding to me, was that my girlfriends told me that I could do better. So, I know we've all heard that story before. So I sat back and I learned more about a cottage industry called the Certified Divorce Financial Analyst business, and I went ahead and got that designation, and I set up my practice. I have 25 years of being a CPA and tax experience, and about 15 years of financial planning experience. So when you marry the two of those together, it becomes a very powerful instrument in the divorce process. My clients are typically the non-wage earning spouse, usually the female in this case, and they sit with me. We work through divorce settlement options. We talk about their assets, help educate them about every aspect of the financial part of their divorce, and we're set up for post-divorce for every aspect that the client might need. Typically, the non-wage earning spouse has to go out and find 4 or 5 new advisors: a CPA to do their taxes, a financial advisor to manage their wealth, an insurance agent. Usually the husband has had all those relationships, or the wage-earning spouse, and we have all those inside of our practice. We have a tax practice, financial planning practice, an insurance practice, and a mortgage practice. So with one phone call to someone that they've been working with over the last 6 months to a year, we're able to help them through the whole process. And we pride ourselves on trying to make the process more efficient and more cost-effective for the client by educating them so they walk into the room as an educated decision maker.
Well, that's great. And Mike, you've sort of done a nice segue into what I wanted to ask next. You've already described sort of what you initially look for clients. Let me ask JoAnne, when someone comes in for the first time, walk us through what generally you try and do the first time you meet a client or potential client.
Are you talking about mediation clients or coaching clients?
Either one or both.
Well, with a coaching client, it's important to let them talk for a while. We want to hear what their story is. We want to see what their perspectives are, and certainly we want to know what their concerns are. And through learning more about those three things, we work together and help them get a plan together. In a coaching situation, it may be which experts do you need, what kind of advice do you need, and importantly, what questions do you need to ask. Many people who are facing divorce in the beginning stages literally don't know what to do first. They don't know what to do next. And having a guide there who is familiar with the divorce process can be of tremendous benefit to them. You know, divorce is about two things. It's about business, but it's also about emotions. And that emotional component can have a tremendous impact, even on getting information together, making decisions about that information, and certainly making decisions as you get toward the end of the process, which is a very important time for them.
So Steve, when clients come to see you, what is the first thing that you focus on with them? And part B of my question is there a difference in the advice that you give someone who is maybe the higher earning spouse as opposed to either the non-working or the lower earning spouse?
Thank you, Millie. We have a lot of overlap with what JoAnne has just described. People come in to us and they don't know what their rights are, they don't know how the process works. There's a lot of fear, there's a lot of anxiety, and in a number of instances, somebody needs to tell their story for the first time to someone who's going to listen. That's the emotional part that we've just heard about. And what we're listening for is, what are the issues in our case? Are there minor children? Is there someone with special needs? Is there a parent who has become a dependent? Is there a business? Is there a retirement? So we're identifying what are the legal issues going to be. In terms of your Part B, if you could refine that a little bit more for me.
Well, do you, for instance, in preparing for divorce, people, I would think, naturally start to look at their assets and say, I want to make sure I get this asset. I want to make sure I get the money out of the checking account, the savings account, the investments. And do you advise people to start making moves with their finances before divorce, or is that something that shouldn't be done until we're in the middle of the process?
Okay. Before the process, if there's no case filed, there are no ground rules. It is you're in a marriage, and people who have joint accounts, for example, have access to these accounts. The things that I look for is making sure that somebody's going to have access to funds to live their life during the course of the marriage. If there's a situation where everything is in one spouse's name, that person can bring a whole lot of financial pressure on the other person by cutting them off. So as we were actually talking before we went on the air, one of the first things I'll do is to say, do you have access to liquid funds? Next, we take a look at what are the current bills and financial obligations, and we make sure that that's getting met. And we determine very early in the process, do we need to go to court right away to get a temporary order to ensure what the responsibilities will be for who's paying what. In terms of the moneyed spouse, my background is that before practicing family law, I took a diversion from what would have otherwise been the middle of my legal career. I was admitted to practice 24 years ago. But for 6 years, I was a financial advisor with Payne Weber, which was bought by UBS during that time. So I'm familiar enough with the some of the details. I can't substitute for Mike, and that's why I've brought Mike in on my cases. But to take a look at what somebody has and listen to what's important to them. If I've got a business ownership in the business and not having that divided is a natural, but we have to make a determination as to what is marital property, what might be some separate property. If I've got perhaps a second generation in a family business, and determine what is allowed by the court to be divided and maybe something that might be protected. We also, just to wrap it up, we see, is there a prenup in place that might have already established some ground rules?
Mm-hmm. What about you, Mike? Do you advise clients to move money ahead of, when they're just starting to think about divorce, or do you advise them that really is something that shouldn't be done? Right,
that's a great question. And typically I get involved very early on in the case, but they usually already have an attorney at that point. And in most cases I've already filed, but Steve was right on target when he talked about liquidity. We all have cases where our clients have lived the millionaire lifestyle, but they've been cut off by funds because they didn't properly prepare, and now they're starved out, and they're looking to get access to funds, and that's where Steve has to go back and petition for funds. So we do talk to them about liquidity and the importance of it, and to start planning for post-divorce life, because their life is going to be very different. Everybody goes backwards financially in divorce, and that's a hard concept for people to grasp and really digest. And I think working with JoAnne and the clients that she sent to our way, they come in a lot more educated about the process and know what to expect, so we're able to get down to brass tacks a lot faster, as opposed to helping them process what's really happening.
When I called you, Mike, and asked you about doing this show, I was surprised to hear how far in advance many of your clients come to you, and since I don't do that kind of work, that surprised me. And you just indicated that perhaps for you as well, JoAnne, folks come to you long before there's actual legal papers filed. They may well have attorneys, and everyone knows it's going there. Tell us about some of the pre-divorce things that you focus on in coaching and or eventually perhaps mediation.
Thank you, Robert. The best time to see a divorce coach is at the beginning of the process, because this is in the planning stages. It's before you've made some mistakes that you should avoid. And the sooner you get some guidance on what to do first and what to do next and how to get organized, the better off you are. One thing we run into a lot, and is a common mistake that people make and reinforces what Mike just said, it's very difficult to move from one household into two households from a financial standpoint. And there's a lot of denial and a lot of unrealistic expectations about what that's going to look like. People want to continue the same lifestyle they're leading, and the financial realities usually indicate a much different type of lifestyle. So that's difficult for a lot of people. And the more familiar they get with their financial information, the easier those decisions can be. But understanding the financial numbers is a key to that. And one thing we tell people is to put together a brains book. And this is a 3-ring binder. We tell people to get all the financial information together that they can. I also warn them gathering the information is not enough. You have to gather it, you have to organize it, you have to read it, you have to understand it, you have to digest it, and you have to be fluent. Because you can have the best advisors in the world, you still have to be the CEO of your own divorce. And during this process, information and knowledge are your two best friends.
I love that phrase, a brain book.
Yes, and it's been very helpful to many people. But you have to know the details of your own divorce.
You're listening to Wealth Matters, the radio show where we discuss the opportunities and challenges of preserving and managing wealth. We are your hosts, Robert Port and Millie Baumbusch, from the fiduciary litigation law firm of Gaslowitz Frankel. We're discussing the financial consequences of divorce with Steve Kirson, senior attorney with Kessler and Solomiany, Mike Bean, founder of Divorce Sense, and JoAnne Donner, founder and president of Donner Mediation and Coaching. So, JoAnne, in your experience, when your clients put together the brain book, as you say, with all their financial information that they should understand well, are they often able to do that? I mean, that is the goal, but how often do they bring together the information but just really don't understand what's going to happen in setting up two households and what's going to happen in the future? I mean, things they need to do about, for instance, changing beneficiary designations on accounts, or even estate planning, all the tasks that come after divorce.
Well, thank you, Millie. To answer the first part of your question, every divorce is different. Every mediation is different, and this fact becomes clearer every time I do a new mediation. So everyone handles the Brains book a little differently. You know, some people put a mountain of information in there, but it really isn't useful unless you understand that information. So taking the time to gather the proper information is important, and if you don't understand something, you have to take the time to find the expert who can explain it to you. So it is very important to, as I said, gather, organize, and also understand what you are talking about.
If I can jump in on that, your point is very well taken, that it's not just gather together the information. In every case that is filed in the courts, we put together by rule of court, Rule 24.2, a domestic relations financial affidavit. This is the backbone of every divorce settlement or court decision. It includes a budget for all of your monthly expenses. It includes your income from all sources and a listing of assets and liabilities. And then I take a look at the information that I get from my clients, and sometimes I will look and I will see a listing of an asset, $1 million asset. It's a life insurance policy, and they've added the $1 million into their total of their net worth. It's a term life insurance policy. And there are a lot of very successful people out there who are very good at what they do. They earn a good living, they have assets, but they may not exactly understand what those assets are because that's not their thing. They run their company and they know they have this, and sometimes I've found myself being the person who for the first time is saying, that's not $1 million asset, at least not to you in your lifetime it isn't.
That's right. That's a good segue into the question of defining a term you used earlier, Steve, which was marital property. So can you talk a little bit about the distinctions between marital and separate property, and from my perspective, how important that is as you go through the process vis-a-vis the financial consequences of a divorce?
Sure, Robert. The distinction is that marital property, and these are all generally speaking, they can find an exception somewhere in the case law, but generally speaking, anything that is acquired during the marriage through marital efforts and labors. So something that after a couple gets married, they go out and purchase, that's marital property. Something that is acquired with your earned income during the marriage, that's marital property. Something that is purchased with funds that came out of a joint account, that's marital property. Marital property in Georgia is subject to what's in this state called equitable division. If the parties can't themselves settle out on who's going to get what, Mike gave the reference to, it ended up being 99% what they as individuals recommended, then the court will settle it out. The court is empowered to divide marital property. So your question as to what is separate property, I could say that's everything else, but what everything else means is it's what did you have prior to the marriage? What did you bring into the marriage? And then what did you keep separate? If a person gets married and they have $100,000 in the bank, and then that would be separate property. If after getting married they deposit that into a joint account that gets commingled with both people's direct deposits from their earned income during the marriage, we've just transmuted that into marital property. We've transformed it. Also, something that you would inherit from a relative during the marriage, that will be separate. Again, so long as you don't then commingle it with marital property. Gifts that are directly to you during the marriage, that will be separate property.
Robert, if I could add
Absolutely.
on, just add a level of complexity to what Steve just talked about.
Or you want to complicate it? Okay, Mike.
Absolutely do. There are assets that are considered both marital and separate, and what I'm talking about is a simple thing like a 401k. Somebody comes into a marriage and they're at the same job while they get married. They had a balance of, let's say, $100,000, using Steve's example, in their 401k. They get married and they continue to contribute during the marriage to that 401k. And then they file for divorce. Well, from what we do is we show part of that asset, the $100,000 plus the growth on that $100,000 over the course of the marriage, is considered separate property. And that becomes a pretty lengthy calculation. And a lot of clients don't understand that. Why isn't that whole thing marital property, or why isn't it separate property 100%? Because I started this contributing before I got married. And the same thing could be said with other assets, stock options, another level of complexity there, where options are earned but may not vest until after the divorce. And there's calculations there we call coverture calculations, where we have to carve out the marital portion and then the non-marital portion.
Houses, don't forget houses.
And houses also. So there are complications to assets, and everything is not as simple as things might appear to be on paper.
Right. It seems to me, hearing all three of you speak about this, that what may happen conceptually is someone puts together JoAnne's brain book, and then Steve and Mike need to figure out, and sometimes, as you say, with very complex financial calculations and an understanding, maybe looking back where the funds came from, what happened to them, so on and so forth, then try and sort out what goes in what pile, marital or not marital, and sometimes, as you say, an asset may be a little bit of both.
Right. In a perfect world, I think both Steve and I, if I could speak for you, Steve, would love it if our clients came in with JoAnne's brain book. Unfortunately, typically it's a laundry basket full of documents, and we're putting things together for them.
Well,
Let's throw one more term into the mix, community property. I know that Georgia is not a community property state, but what if you're a Georgia resident and you happen to own maybe a vacation home in a community property state? What does that do?
I think the solution there, Millie, is that the property that's located in a community property state will itself be subject to community property. And though I went to law school in Louisiana, which is one of the 8 community property states, I'm not going to speak to community property. I took the common law courses. I knew I was going to be moving on. But the thing to do there is for your local counsel or your local coach to contact someone who is a community property lawyer, most probably from the state where that property is located, and associate them as co-counsel, because that will be one element of property that will be controlled by the state in which it sits. Just as if people were married in a community property state, but if they've been in Georgia, a non-community property state, and this is where they're getting divorced, this is where the law will apply to them, and generally speaking, it's not a community property divorce with the exception of that property.
Okay.
Let's talk about an area that often generates cases within our practice area of fiduciary litigation. And let me just ask generally, what is the effect of a divorce on an existing will or someone's current estate planning?
My understanding is that when there is a will in place and there's a divorce, if that will is not replaced during the case, then it treats the other spouse as if they have predeceased you. And I guess that ends up being reciprocal, so that you go on from there without the obligations to inherit in place, because they're considered by law to have already been deceased. However, my recommendation for people when they come in is, first, do you have a written will? And that's a question the other side is asking as well. And then number 2, do you want to go out and get that changed while this is pending? Because if something should happen to you tomorrow, do you want this person who you are no longer willing to be married to get all your stuff? And unfortunately, last year in 2015, I had a case that was very sad. Person had not made changes to the will and did die during the case. And there was not only a problem with the person that was getting divorced, who was not going to be getting half, but was going to be getting all. But during a period of infirmity, that spouse was the person named on medical directives and powers of attorney. And in fact, we had to consult with one of your partners, Adam Gaslowitz, about what to do for that person.
So I'm wondering, JoAnne, whether your brain book also includes a request to the client for estate planning documents, powers of attorney, healthcare powers, and things like that, so that financial consequences of a divorce, if the unfortunate happens, are also at least known and can be thought of.
Well, thank you, Robert. You bring up some very good points, because there are many. Divorce is such a multi-layered process. There are so many things to think about, and the items you just mentioned frequently get overlooked. So the Brains book can play a role in that. We always say go out and buy a 3-ring binder with colored tabs and make a tab for every category. And certainly the healthcare directives, wills are things that should be addressed and can certainly go in there. One financial factor that people do overlook as well is the post-divorce budget. I have had people come into a coaching session after many, many years of an unhappy marriage. They've decided to bite the bullet and move forward. And unfortunately, many times people make that emotional decision, but they don't pay attention to the financial details, including where am I going to live? How much is that future rent going to cost? How am I going to pay my bills? I haven't been in the workforce for 10 years. So all these issues need to be addressed, and the post-divorce budget especially is critically important. That is the number, how much money am I going to need every month to live? That is the number that can inform so many decisions moving forward. How much should I be asking for in spousal support? How much am I going to need in child support to make this work? So the post-divorce budget cannot get too much attention, and unfortunately many people don't think in those terms.
And JoAnne, I think that is the most powerful advice that you could give to anybody. I think the light bulb moment for my clients are when we take that post-divorce budget and we start applying settlement options to that post-divorce budget and apply financial planning techniques to it, whether we have to draw down assets to survive. And what we often see is the settlement offer that came across the table that was so offensive when we read through it is actually something that is feasible and we can live with it. And then the decision becomes, do we want to continue to fight? How much do we want to spend to fight to get an extra inch, an extra yard? Or, you know what, actually you may think you're being generous with the settlement offer, but from a cash flow perspective and an asset perspective, I cannot live. I'm going to be out of money in a couple of years, and so we need to continue to fight. So when you put all those tools together, you are able to make an informed decision. And I couldn't agree with you more about the post-divorce budget. I think that is the most important aspect of part of your preparation for the divorce process.
And surprisingly, frequently overlooked. Don't you find that, Mike?
Absolutely.
Yeah.
JoAnne, my question that's coming to mind here as you're talking about the post-divorce budget, one of my frustrations when I've got someone who's not working with a coach like you is folks will, and it can, sorry to be stereotypical, but sometimes it is a non-working spouse who has been the person running the home, forms an attachment to what I would call too much house for post-divorce life.
You are reading my mind. In the last several mediations we've been involved with, holding on to the marital home has become a huge issue. And that emotional desire to keep children in the same home that they've lived in so they don't have to change school districts, so they have the same friends, the same activities, becomes a very motivating force during divorce negotiations. However, that desire to hold on to the marital home can be very removed from the financial realities that exist in that divorce, and that is a very difficult leap. And many times the woman will say, well, I'll refinance. The ugly reality or truth to that is it's a lot easier said than done. You need certain requirements, certainly for income and assets, and a person who has not been in the workforce or is in a low-paying job is in a much more difficult situation than they can imagine. Flip side is the husband's name is on the mortgage and the wife's isn't. But the wife is the one who wants to stay in the home. How long is that husband going to be willing to keep their name on a mortgage on a home they're not living in? Perhaps they're going to keep their name on the title. It becomes very convoluted, but it's an issue that a lot of people have not thought through.
Where we look ahead in that is we try to come out of a divorce with as clean a division as we can, and I see Mike nodding his head too. we don't want people to continue to still be in business together. If they're going to continue co-owning a home, now they're going to have to start discussing every repair. Does a repair come along at a time and a point where it makes more sense to do an upgrade because it's a 20-year-old room in the house? And those financial decisions are probably the type of things that they were disagreeing with each other about on the way to getting divorced. And so we really try to come up with a settlement that within, if it's not 6 months, 12 months, gets both names off the house. And if it can't remain in the name of the one person who's looking to stay, then we need to look to Plan B.
Right, and I think what people need to understand is if the non-wage earning spouse wants to keep the house and refinance the house into her name, it's going to take 6 months of what we call seasoning of receiving child support and spousal support before they can begin to qualify to refinance. And you do not want strings attached as much as possible, you're right, because people move on with their lives and it becomes more than just a financial decision. People start dating and maybe even get remarried. And when you're still tied to your ex-spouse, that's when it can get really ugly again.
Steve, you mentioned home inspection. A colleague of mine said, we always think of a home inspection as something we do when we're buying a house. It's also advisable for a spouse who wants to keep a house and may be getting the house in the settlement agreement to get a home inspection at that time, because you can turn around and you might need a new air conditioner, a new heating system, a new roof, or things that are more hidden than those. So a home inspection can be a very valuable piece of information at various times throughout the divorce process.
You're listening to Wealth Matters, the radio show where we discuss the opportunities and challenges of preserving and managing wealth. We are your hosts, Robert Port and Millie Baumbusch, from the fiduciary litigation firm of Gaslowitz Frankel. We are discussing the financial consequences of divorce with Steve Kirson, senior attorney with Kessler and Solomiany, Mike Bean, founder of Divorce Sense, and JoAnne Donner, founder and president of Donner Mediation and Coaching.
I had a question that's related to, I guess, your the post-divorce budget, which is spousal support or alimony for the lower earning or non-earning spouse. What have the trends been with that recently, and is that still something that is generally awarded?
Well, I'll defer a little bit more to Steve, but what I've been seeing is that spousal support has not been receiving as much attention or favoritism from the courts as it used to for several reasons. But Steve, you see this a lot more than I do.
We do, and it is really, alimony is something that is on the way to going away. It's not gone entirely, but it is an expectation of the courts that people who are able to work will go to work. And the generations of folks who are, the exceptions to that end up being people who at this point in time might be 30, 35 years out of the workforce and just plain stayed home, maintained the home front, raised the children, and it's just too late to re-enter the workforce. But we're very often seeing folks who may be out of the workforce 20 years, but they're in their mid-40s, and there's still a long way between where they are and traditional retirement age. And alimony will be on a limited duration and is considered rehabilitative. Here's something to allow you to meet your expenses while you acquire the new skills and work to get up to speed to get back into the workforce. It's a byproduct of the women's movement that we've seen for however many decades now, that the old alimony came out of a different era.
I've noticed something extremely interesting in the last few mediations we've done, and that is two wives in particular did not want spousal support.
Hopefully not two wives of the same husband, right?
No. Good point, Robert.
Was this a Utah? No, go ahead.
And I found that very interesting. Emotionally, they took affront to that term. They may want more in a property settlement to perhaps make up the financial difference, but they did not want the term spousal support to be discussed, or they didn't want a financial settlement that included that. And I found that part of this trend that you're both talking about, so I found that very interesting.
Are there other trends that you are seeing with regard to support for children? Is that, more of now both spouses are equally responsible for children's health and education expenses, that kind of thing?
We redid in Georgia the child support guidelines about 10 years ago and went to what's called an income shares model. Previously, you would look to the non-custodial spouse, which historically had been the father, the husband, and you simply, based on the number of children, took a percentage of gross income, and that was child support. With the new guidelines, and they're not so new anymore, it's you take a look at the combined gross income of both parties, and there is a table, much like a tax table, that based on the number of children and the combined gross income, there's a basic child support amount, and that is then allocated between the parties based upon what percentage of the income. So if one spouse is making $100,000, the other makes $50,000, and you look up for two children and you find the amount, 2/3 of that amount would be allocated to the higher earning spouse, and if that's the father and he's not the primary custodian, that's his basic child support amount. The effect has been from upper middle class and up, a reduction in child support in Georgia from the prior guidelines. This is no longer as attractive a state for a child support amount as it used to be, and that can be a challenge.
One thing we're finding with child support, as Steve is saying, it is a formula in the child support worksheet. Many times couples want to add supplemental child support. They may want to talk about college. The courts really don't get into college because the children at that point are older than 18 years old. But they may want to add in their agreements supplemental child support or financial support for children about college, maybe something extra for extracurricular activities, and we're seeing a trend toward that in the last several months as well.
We spoke earlier about assets that would pass pursuant to a will. How about assets that don't pass pursuant to a will? Life insurance policies, retirement accounts, property held with rights of survivorship. In our litigation practice, we often see cases where beneficiary designations are not changed after a divorce, and down the road, someone who will be claimed not to be entitled to money gets money, or someone who is obligated to get insurance doesn't get that insurance. Can any of you speak to how you deal with those issues? Because I think what I see as part of the risk is that the client, although told, you got to change your beneficiary form, you got to deal with this, as with many other things, it sort of falls by the wayside.
Yeah, that's a good point. I think a lot of clients are just so wiped out emotionally by the divorce litigation process that when the paperwork is signed, they just take a back seat for a while and they let loose ends kind of go by the wayside. So I think it's real important as part of our practice that we make sure to revisit those concepts real quickly. I have not seen a situation where a beneficiary has not been changed and somebody passed away, so I can't speak to that, but it is an important part of our practice that we make sure that those beneficiary designations do get changed.
The general rule that we see is something that is a payout by contract, such as an insurance policy. If the beneficiary isn't changed, then it's going to the ex-spouse. There's been a little bit of case law exceptions if part of a settlement includes a very broad and yet very specific disclaimer on such interests, where there was a case, Lowry v. Fensel in 2015, where the court sort of covered up for someone. He hadn't changed some designations on retirement accounts, and they sort of saved his estate and ruled that the former spouse had effectively waived the interest in those accounts. That was a particular case with good language and a settlement. The general rule is you will lose out. I recently had a client whose former husband did not change a life insurance policy that he was entitled to change. That was a windfall for my former client. But the former spouse who passed away, he had plans elsewhere and they didn't get followed through on.
We have seen several claims against estates that relate to things that should have happened during divorce. And I can think of two examples. One is client comes, her father had passed away. She's now in her 30s, but dad had never paid the college expenses that he was contractually required to pay under the divorce decree. And now she wants to come and sue his estate for those payments. Second thing I've seen is a father who was required to keep a life insurance policy naming his children as a beneficiary. He never established it. He never set it up. The children now are suing his estate. Do you see things like this happening? And is there any statute of limitations that you're aware of that would prevent claims against estates for things that may have happened or didn't happen pursuant to a divorce decree that can be 10, 20, 30 years old?
I'm actually going to put the statute of limitations back on y'all, since you are the folks who end up litigating those claims. We're on the front end. The danger for a divorce settlement agreement is, as you say, it may be 10 or 20 or 30 years later that folks come out and say, oh, we didn't realize we had to address that issue. And one of the biggest paranoia points is the concern of, how do I know he's going to pay the premium? How do I know that the beneficiaries aren't going to be changed? We can put language in that makes a court requirement to provide on an annual basis, or if we really want to be pesky and nosy, try to get semi-annual, quarterly, a statement from the insurance showing that it's in force and that the beneficiary designations are as they're supposed to be. Your remedy, if the person hasn't done it, is to go to court, which people don't want to do, on a contempt of court claim. But that is an issue that is important. We try and put in as strong a language as we can that would say, if the person who's required to have this insurance policy fails to do so, then the other party would have a claim against the estate. And we'll put that right in the settlement agreement so it becomes an order of the court against the estate for those amounts.
Does this kind of go against the concept, though, you talked about at the beginning, where you say if these two people don't get along and we want them to be divorced, we want them to be divorced financially. So maybe it's not a great idea to have ongoing financial obligations that keep them tied together.
Where we will see insurance policies will be during the time that there is some other financial obligation to cover the amount of child support. So if you're getting divorced and there's another 6 or 8 years of child support until the kids finish up high school, that would be the length of time that life insurance might be required. Similar for an alimony, although the law is more favorable to a requirement for life insurance to back up child support, there is no requirement for that for alimony, although sometimes it's something that would get negotiated. But no, for lifelong, just simply, hey, I'm your ex-spouse, and if something happens to you, I want to get $1 million. No, that would, in fact, I've had people who specifically have said, I don't want my ex-spouse to have a financial interest in me dying.
I think that we have probably about 1.5 million questions more that we could ask all of you. But this is a very complex topic, but we may be out of time. So before we go, I'd like to ask each of you to provide your contact information, your website, social media, something, whatever you have, so that listeners can get in touch with you. Let's start with you, Mike.
Sure. Thanks, Millie, and I appreciate that. Thanks for having me as a guest. Name of my company is Divorce Sense, the dollars and cents of your divorce. My website is www.divorce-sense.com, and you can reach me at mike@divorce-sense.com, 770-790-5050.
JoAnne?
Thank you, Millie. Thank you, Robert. I certainly enjoyed being with all of you here this morning. My name is JoAnne Donner. My business is Donner Mediation and Coaching. My phone number is 770-842-9400, and the website is www.mediationandcoachingllc.com. Thank you.
Steve?
And I'm Steve Kirson. Let me spell the last name, because most of your listeners don't know anyone with my last name. Last name is Kirson. On the web, My law firm, Kessler and Solomiany, can be found at ksfamilylaw.com. Telephone number is 404-688-8810. My email is skirson, skirson, at ksfamilylaw. And thank you both for including me in this morning's talk.
Well, thank you all for joining us. As we are wrapping up our show, I want to thank everyone for listening to Wealth Matters, where we discuss the opportunities and challenges of preserving and managing wealth. For more information about Gaslowitz Frankel, please go to our website at gaslowitzfrankel.com. And remember to follow us on Twitter at Estate Dispute and use our show's hashtag Wealth Matters. Our guests today were Steve Kirson, senior attorney with the domestic law firm of Kessler and Solomiany, Mike Bean, founder of Divorce Sense, and JoAnne Donner, founder and president of Donner Mediation and Coaching. Please join us every fourth Wednesday of the month at 8:30 a.m. here at Wealth Matters on Business Radio X.